Welcome to this deep dive. We're continuing our journey through the Manual of Patent Examining Procedure, the MPEP.
That's right.
Today we're tackling Chapter 2100, Patentability, and specifically we're zeroing in on Section 2105.
Which covers patent-eligible subject matter, living subject matter.
Exactly. And, this whole series is thanks to Mike Shepard for organizing everything, so a big shout out to him.
Definitely.
Now, talking about patenting life, living things,
Sure.
it sounds really modern, maybe even a bit sci-fi, but this isn't exactly a new debate, is it?
No, not at all. That's a really important point. For quite a long time, it was genuinely uncertain whether living organisms could even be patented. So our goal today is to unpack how we got to the current understanding. We'll look at the key court cases and the laws that now shape what kind of living things can get a U.S. patent.
Okay, so where's the starting point for figuring this out? Sounds like there must have been a specific case or moment that really changed things.
Absolutely.
Yeah.
You really have to start with the 1980 Supreme Court case, Diamond v. Chakrabarty. That one's the cornerstone, really.
Chakrabarty, okay. What was that about?
It involved a bacterium genetically engineered by Dr. Ananda Chakrabarty. And this bacterium was pretty special. It could break down crude oil components.
Wow, okay, like for oil spills?
Exactly. Something no natural bacteria could do in quite the same way. So a very clear potential application.
Right. So a human-designed organism for a specific job. What did the Supreme Court say? Could you patent that?
They did. The court's decision was, groundbreaking. They said, yes, this engineered bacterium was patent eligible.
And why? What was the reasoning?
They basically looked at the patent law, which covers things like a manufacturer or a composition of matter. And the court said, look, whether something is living or not isn't the deciding factor under those categories. What mattered was that Chakrabarty's bacterium was, made by humans. It was a product of ingenuity.
So it fit the definition of a manufacturer or composition of matter.
Yeah, precisely. And crucially, it had characteristics markedly different from anything found in nature.
Ah, markedly different characteristics. That sounds like a key phrase.
It absolutely is. It wasn't just alive. It was different in a significant way because of human intervention. That alteration, that new capability, that's what made it patentable.
Okay, so that case really set the stage. It opened the door, so to speak.
It did, big time. It established the principle that modified living organisms could be patented.
And I guess things didn't stop there. The MPEP mentions this idea being applied more broadly later on.
Yeah, the principle got extended. After Chakrabarty, the courts and the Patent Office kept refining this. The MPEP points to a case called Ex parte Allen.
Allen, right. What'd that add?
That was a decision from the Board of Patent Appeals, and it affirmed that, yes, even certain genetically altered animals could be patentable subject matter.
Whoa, animals. Okay, that feels like a much bigger step than bacteria.
It was significant for sure, but the logic followed directly from Chakrabarty. If you modify a non-human animal so it has new, useful traits not found in nature, it could be seen as a manufacture or composition of matter, just like the bacterium.
I see. Still comes back to that human-made, markedly different idea.
Exactly. And soon after that Allen decision, the USPTO, the Patent Office, actually put out an official notice.
Okay.
It confirmed that, yes, non-naturally occurring, non-human, multicellular organisms, and that includes animals, are eligible for patents under Section 101.
So the policy became official. What about plants? They're living too.
Good question. Plants were also addressed by the Supreme Court, this time in a case called JEM Ag Supply v. Pioneer Hybrid.
Right.
And the court said, yes, plant varieties can be patented under the General Patent Law, Section 101.
Even though there were already specific laws for plants? Like the Plant Patent Act?
Yeah, that was part of the issue. Things like the Plant Patent Act and the Plant Variety Protection Act already existed. But the Supreme Court clarified that those specific laws didn't stop plants from also being eligible under the main patent statute, Section 101, if they met the criteria.
Okay, so the overall trend seems to be allowing patents for living things, as long as they're, sufficiently modified by humans.
Generally, yes. But there are definitely important limits. It's not a free-for-all.
Right, there has to be a line. What isn't patentable then?
Well, a really key limitation comes up with cloning. Just making a genetic copy of an animal isn't enough.
Ah, okay.
The case in Roslin Institute is the big one here.
Roslin Institute.
Yeah.
That sounds familiar. Is that Dolly the sheep?
That's the one. Dolly, the famous cloned sheep. The Federal Circuit Court looked at that case and said, nope, not patentable.
Why not? Cloning is obviously complex technology.
It is, but remember that key phrase, markedly different characteristics.
Right.
The court found that Dolly was essentially a genetic duplicate of the sheep she was cloned from. She didn't have those markedly different traits compared to the original naturally occurring animal.
So even with all the human effort involved in the cloning process, the result wasn't different enough genetically.
Exactly. The focus is on the final product, the claimed invention. Does it have significantly different biological characteristics from what nature provides? A clone, by definition, doesn't. It lacks that crucial inventive difference at the genetic level.
That makes sense. It separates the process from the product's inherent novelty. Now, wasn't there also a specific law passed about humans?
Yes, a very important one, Section 33A of the Leahy-Smith America Invents Act, the AIA.
Okay, the AIA. What does Section 33A say?
It's very direct. It states that claims directed to or encompassing a human organism cannot be patented, period.
So an absolute prohibition on patenting human beings.
Correct. And the MPEP notes that this law basically just wrote down what had already been USPTO policy for a long time.
I see. So it codified an existing understanding.
Pretty much. The idea behind it is to, allow and encourage patents for life science innovations, things like modified human cells for therapy or genetically engineered animals used to study human diseases. But to draw a very clear line saying you cannot patent a whole human being or a human embryo, it's an ethical boundary set into law.
And how does that play out in practice for the patent examiners?
They're trained to look very closely at the claims in a patent application. If any claim interpreted in its broadest reasonable sense could potentially cover a human organism,
Then it gets rejected.
yes, it gets rejected under Section 101 for eligibility, and specifically citing this AIA Section 33A.
Yeah, the MPEP uses examples to make these points clearer, doesn't it?
Yes, and they're quite helpful. Think about, say, a genetically modified oyster. Maybe it's been engineered to produce a specific drug.
Okay.
Because it has structural changes, genetic changes that aren't found in nature and give it this new ability, it likely would be patentable.
Because it's got those markedly different characteristics. There's that phrase again.
Exactly. Now, contrast that with, say, a claim for a cloned cow that's just a genetic copy of a prize-winning dairy cow.
Right, like Dolly.
Right. That claim would likely be rejected. It lacks the novelty, the meaningful biological difference created by intervention, not just replication.
So it really hammers home that distinction between modification and mere copying.
It does. It's about creating something genuinely new at a biological level, not just finding or duplicating what's already there.
Okay, so if we zoom out and look at the whole picture for patenting living things in the U.S., what's the summary?
Well, the big picture is that it's this framework built from, 1, key court decisions like Chakrabarty, and 2, specific laws like the AIA's ban on human patents.
Right.
The core idea is, if it's living, but it's non-naturally occurring, and it has been significantly changed by human hands to have markedly different traits, it can be patent eligible. But that doesn't include things just found in nature or things that are simply genetic copies like clones and absolutely not human organisms.
Yeah, it really sounds like a balancing act.
Eh.
Trying to encourage innovation, especially in biotech, while respecting some pretty fundamental ethical lines.
That's a great way to put it. And it's an area that's constantly being tested, Science keeps advancing, creating new possibilities, and the law has to adapt and interpret these principles in new contexts.
So for you, the listener, that was our deep dive into MPEP Section 2105 on living subject matter. It's definitely a complex area where science and law intersect.
And because it is complex, it's really important to stress that this discussion is for educational background. If you're actually working on inventions in this space, you absolutely need to consult the official MPEP itself, or better yet, talk to a registered patent practitioner who specializes in this area. They can give you advice specific to your situation.
That's really critical advice. Definitely don't rely just on our chat here for making real-world decisions.
Absolutely not.
Okay, so as we finish up, here's something to chew on. We're seeing incredible biological tools emerge, like CRISPR gene editing, synthetic biology, creating life forms in ways we couldn't imagine just a short while ago.
Yeah, the pace is amazing.
So the question for you is, how will these future breakthroughs continue to push on this legal framework? How will we decide what new forms of life can, or maybe should, be patented down the road? Definitely something to think about.
It certainly is.
Thanks for joining us for this deep dive.